Hi, I'm Diane Drain, Arizona bankruptcy and foreclosure expert, and also a law professor. I want to talk about who can file bankruptcy. I get that question all the time. In the first place, people call and say, here's my situation, can I file bankruptcy? And I explain to them that bankruptcy is a constitutional right. So yes, you can. What the real question is, should you file? There's a lot of preparation that needs to go on before filing, and it's not unusual. I would say 1 out of 3 clients that I talk to don't file bankruptcy for many different reasons. But filing bankruptcy has to be done with thought and planning. Now the next question, if they're married, is do I have to file with my spouse? Okay, and that answer is no. No one has to file bankruptcy. Just because one spouse files, the other one does not have to file. What is the norm in Arizona? The norm is that they file together. So unless there's a reason why only one is filing and not the other, then you really don't want to be outside the norm. Otherwise you start to draw attention to yourself. What would be reasons why you would file separately from your spouse? Let's say it's a brand new marriage. All the debts are yours. Certainly you wouldn't want your spouse to be filing in that case, because there's no community obligations. You haven't taken out any credit cards while you've been married because it's a brand new marriage. So in that case, you would file on your own. You would not file with your spouse. But your spouse's income certainly has to be attributed in your bankruptcy. Another reason for filing separately is, say that the majority of all of the debts were business type debts and guaranteed by just an individual, not guaranteed by the spouse. And that starts to be very sophisticated in analysis. I'm not going to get into that here, but just know that in that particular case, the individual may be filing on their own. Again, there may be some blowback on their spouse though, because the debts are going to include all community obligations. Sometimes a spouse doesn't want their other spouse to know that they're filing, and they think somehow or other they can sneak this through, which is kind of sad and amusing at the same time. It's not going to work. I'm sorry, it's just not going to work. So both spouses have to be part of this picture, not necessarily that both file, but they both have to be part of the analysis. In fact, I even require that both be on the phone, even though one is positive that they're going to file on their own. The reason for that is that when the person who files bankruptcy, by law, they have to list all of their debts. That would include the American Express bill, for instance, that they took out while they were married. Well, their non-filing spouse is still liable on that American Express bill. But if the filer gets a discharge, their spouse also gets a discharge. And that will show up on the non-filer spouse's credit report as discharged in bankruptcy. Now this is much more complicated. I'm not going to get into community property issues and all right here, but I'm just saying that just because you're married doesn't mean you have to file together. But you have to think it through with somebody who can guide you down the path and understand what the full breadth of the issues are that both you and your non-filing spouse might be facing. So I hope that was helpful. You take care.